are not possible in other countries. If anyone not coming under this test is not an employee, he will be called as a independent contractor. Now, I will give you one question. Write down this question. What is the difference between an employee and an independent contractor? An independent contractor. Explain your answer with decided cases. Explain your answer with decided cases. All right. Start. Employee involved. Is that right? Hello? You have to talk when you do law. Hello?
Yes, sir.
Okay. Right. Now let's see once again. What are the differences? Meaning, employee, the employee is a person hired by employer to work on a regular basis in exchange of a fixed remuneration. But an independent contractor is self-employed person who provides services to other organizations for a fixed compensation. Source of income, employee salary. Independent contractor proceeds from each project. He will get a final amount based on the project. Employee works for one employer. Employee cannot work for many employers. If they want, you have to get the permission. Contractor works for multiple clients. He works for multiple clients. Contractor, he can be a plumber, electrician, curator, not only for one, he works for many. Inputs provided by employer. Machines and everything for the employee provided by the employer. For the contractor, use his own inputs. Nothing given. You have to bring everything and finish and go. And thereafter you have works for one employer, multiple, yes. Time and place of work decided by the employer, normally his office. Contractor uses his own inputs and contractor decided by the contractor. He can have vary hours, but you have to finish the work and give. Payment for expenses made by the employer for the employee. Independent contractor made by the contractor himself. Independence. Work under the control of direction of the employer. Every time there is no independency for the employee. You work under the guidance as well as directions given by the employer. But independent contractor works independently. The employer cannot give the directions because he is an expert. He will do and hand over the quality work. Otherwise, you can sue him. Delegation is required to personally perform the task. Employer, when appoint an employee, employee must do it personally. You can't appoint other people. He can delegate the task. Independent contractor can delegate the task. Training, employee receives training for performing services in particular manner. Training, the contractor does not receive any training from contracting. Relationship, continuing relationship with the employer. Employer and employee dominant relationship. There is no relationship, employee and independent contract. All right. That's all. Any problem you can ask. Now we go to the today's lesson. This is a recap of what we discussed last time. If any problem, please ask. Any problem, please ask. Okay. Now we go to the other part. Question. What is a contract of employment? What is a contract of employment? What is a contract of employment? Question number 2. What are the contents? What are the contents of a contract of employment? What are the contents of a contract of
Sir, excuse me, sir.
Sorry.
So last time I think we did that one.
Right.
The contract and all this.
ඒකනේ මම අහනකොට ඔයගොල්ලෝ කතා කරන්න එපා නේ. එන කරපු ටික කියන්න ඔක්කොම දැන් මෙතෙක්. Hello, කරපු ටික කියන්න. Hello. Yeah, someone said last time we did it. Can you tell me what are the areas we have done up to now quickly? Hello. What are the areas, please? Hello.
So we did terms of employment contracts, participation, involvement.
No, that is a different lesson. අපි lesson 3යි තාම කරලා තියෙන්නේ මම සිංහලෙන් කියන්න. We have done only 3 lessons. Number 1, introduction. We have done the introduction. Number 2, identification of an employee, the test and the independent contractor. Third one, employee involvement. ඒකේ condition ගැන කතා කරේ නෑනේ. Employee අම්ම සිංහලෙන් පැහැදිලි කරන්න ඕන. Employee involvement and employee participation. මේක employee contract එකක් ගැන කොතනද කියලා තියෙන්නේ? කොයිද කතා කරන්නකෝ එහෙම නැතුව මේ වැඩි කරන්න බෑනේ. Hello. කතා කරන්නෙත් නෑ ඉතින් කොහොමද how can we conduct lessons? Camera on කරන්න ඔක්කොම බෑ අමාරුයි මේ lecture එකට support එකක් දෙන්නේ නෑනේ. වෙන වෙනේමනේ
Sir,
කියන්නේ.
excuse me, sir.
Yeah, කියන්න ඉතින් කියන්න.
Participation, involvement, we had a small discussion.
Yes, that is one lesson. That is one lesson. So from beginning, tell me then what we have done. කතා කරන්න බෑ කොහොමද කරන්නේ? කැමරා දාන්න බලන්න. අපි කරපු ටික කියන්නකො. ඔයගොල්ලෝ කතා කරන්නේත් නෑ. එක එක්කෙනා එක එක ඒවා කියනවා. ඊට small part කියනවා, big part කියනවා, කරේ නෑ කියනවා. We have done 3 areas. Introduction we did. Yes or no? අපි 26ක් ඉන්නවා එක්කෙනෙක් කතා කරන්නකො 25ක් කියනවා time යනකොට. හා? දවස් කීයක් අපි කරාද? How many days we have done? කර දවස් ගන්න දන්නේ. How many times we met? How many times we met, please?
2 days, sir.
2 days. So 2 days we have discussed introduction, and thereafter we discussed employee and independent contractor. We discussed 3 tests for employee identification, control test, integral test, as well as economic reality test. And then we did, again, we have a discussion. And we did independent contract. Third one we did employee participation and employee involvement. It's a theoretical part. It's a theoretical lesson I explained to you. Other than that, what we have done? මේකට අමතරව අපි මොනවද තව කරලා තියෙන්නේ?
So you gave us some questions to find information about industrial democracy, joint consultation.
ඒ ඔක්කොම එන්නේ employee participation and employee involvement ගැන. Employee participation involvement ගැන තමයි ඒක තියෙන්නේ දුන්නේ. Other than that, what I have, huh?
Those two were done, sir.
Yes. So then
Sir,
today contract of huh?
Sir, that questions were asked earlier also. What is the contract of employment? What are the terms in that contract
Yeah.
of employment? All those questions asked last time also, sir.
Right. You gave the
Those
answer
questions
for
were
that.
asked.
Have you given the answers? උත්තර දුන්නනේ? Yes or no?
Yes, sir.
Right. Now today we are going to discuss the type of employees. Write down this question. Okay, I will send, right? A notes among you don't write. Today's lesson, what are the types of employees in your organization? What are the types of employees in your organization? What are the types of employees in your organization? What are the types of employees in your organization? Briefly explain. Briefly explain. What are the types of employees in your organization? Briefly explain. What are the types of employees in your organization? Briefly explain. Right. Start. What are the types of employees in your organization, please?
Sir, full-time employees,
One.
part-time employees.
Don't tell full-time. Permanent employees. Thereafter,
Part-time employees,
part-time employees.
temporary or seasonal workers,
Go ahead, go ahead.
contract workers, internship workers or newly refreshers, freelancers, consultants, remote or telecommuting employees, on-call or casual employees, executive or management group.
All right, I'll display. Can you see this, please? Yes or no? Can you see the slideshow?
You can see.
Yes, I can.
Right. Now see, types of employees in any organization, types of employees basically are these. This is not actually defined by the law, but the employer has defined this. This is the problem. This is where the employer has categorized. And the courts are believing this also. So the types of employees, internship. Interns. Are there interns in your organization?
Yes, sir.
Yes, sir.
Right. Then you have apprenticeship. Apprentices. Are there apprentices in your organization? Yes or no? Hello?
Yes, sir, there are.
Right. So this is the first category. This category basically not earn but to learn. They are learning but not earning. Allowance you may give sometimes. Allowance most of the time you give for them. So interns, they come for 6 months, 1 year, or maximum 3 years. Apprentices are also coming under Sri Lanka Apprenticeship Board is there. They are sending for them to get some work experience. So remember, they are mostly not employee category, but one category you have to go for the next. Trainees. Who are trainees? Are trainees in your organization? Yes or no? Are trainees there in your organization? Yes or no?
Yes, sir.
Right. If trainees are there, what they do? Management training. 1 year or 118 months, something like that. You train them. So they join the organization management training. And then they go for junior executives there. Management trainees are not like interns or apprentices. They are working full time. Only difference, they are getting the training. Salary is little bit low. So the employer get them from maximum work. Then you have probationers. Who are probationers? Are there probationers in your organization? Yes or no?
Yes, sir.
In our, right. So probationers, what they do? What is the probation period of your employees in your organization, please?
6 months. 1
Hello. I am asking a simple question. You all had acted.
6 months.
මේ කතා කරන්න ඕනේ මෙයා ලෝ කරනකොට කොහොම බෑ නිකන් මේ ඉර කරගෙන ඉන්න එපා කතා කරන්න. දන්න දේවල් කියන.
Normally
Minimum
6
of
months.
6 months period.
Normally
6 months period.
normally 6 months period. So one organization, they say probation 6 months. Thereafter only you are taking them for the permanent card. Probationary period, what you check them. Probationary period, what you check from them, employees.
Their suitability to work in the
That's
organization.
right. Whether they are capable, suitable, standards, whether they have the capacity. So after giving the probationary, you may absorb to the company, or sometimes you may extend their service, or sometimes you may not extend their service. So probationary period is something like in Buddhism, Samanera. You know what is Samaneras? In missionaries also there are training temporary period. After fulfilling all the requirements only, you can confirm in the position. So probationary, the judge, not the courts. The judge is the employer, because in the private sector, that is your investment. You cannot get anyone not standard or not capable or not actually learning fast in your organization. So that is one. Then you have probationary period. I have gone through more than 100 company contract of employments. Minimum I have seen 6 months. Maximum practically I have seen 18 months. Universities, they give 8 years probation period to get your qualifications. Once you get your graduate qualification, then you can go to the permanent card. So there is no hard and fast rule in the world. Some companies, they give 6 months. Some companies, they give 8 months. Some companies, they give 1 year. Some 18 months, like that. If there is a probationary period, the employee must successfully complete that. Automatically, you are not given the permanency. Automatic permanency is not there. So what you have to do, the employer must send a letter. We are glad to inform you that you have been placed in the permanent card. If a person has completed his probationary period, still if he is working, he is not a permanent employee. He is also regarded as a still probationer. So the management must in writing give a letter. We are glad to inform you that you have successfully completed your probationary period. With effect from this date, we are place you in the permanent cadre or the permanent position. Or they say probation period completed and then placed in the temporary staff. So in the probation period, all the rights are there. Probation period, all the rights are there for an employee. But remember, he must show his capacity to the employer. Must work hard, get all these assessment correctly. And you have to get the standards perfectly. So all these things are very, very important. So once probationary period completed, you will be placed in the permanent card. In the probation period, there are some cases in Sri Lanka. Earlier, the cases were said Richard Peris versus Jayasuri. There was a famous case, Richard Peris versus Jayasuri. In Richard Peris versus Jayasuriya case, in Richard Peris versus Jayasuriya case, it was clearly stated in the probation period, an employee could be terminated without giving any reason. Without giving any reason. Therefore, the employer basically unsatisfied with the employee, you can be terminated. No need to give reasons. But later on, Dharmasena versus Distrelease Company Limited. Dharmasena versus Distrelease Company Limited, it was stated, even in the probation period, if an employee want to terminate, must give reasons. Otherwise, you have to reinstate the period or So in the probation period, what you must do in the probation period, you have to show your capabilities. Otherwise, if terminated, then what will happen? In Dharmasena versus Digital Release Company's recent cases, what they say, must give reasons. Otherwise, it is unreasonable termination. He can go to the labor tribunal. So time to time, the Supreme Court has also given. Now today cases, the Supreme Court basically say must give reasons. Otherwise, if you terminate, you have to pay compensation. Compensation in that. So probation period, 4 types. They will just state the probation period. Your probation period is 12 months. Another appointment letter I saw, your probation period is 12 months. Immediately after, you will be placed in the permanent card. Another appointment letter I saw, no probation period. No probation period means what will happen? You have no probation period. And another one I saw, your probation period is 12 months and the management has the authority to extend the probation period. So 4 types. Just mention the probation period. Your probation period is 12 months. And then you mention your probation period 12 months. Immediately after the probation period, you are given the permanent card. A wholesome cement, I have seen that. And then I have seen your probation period is 12 months. The company has the authority to extend that period. And I have seen probation period not mentioned in some appointment letters. Then there is no probation period. Now in a probation period, one big question coming up. If the employer has not given the permanency, still you are a probation. Later you can go for a constructive termination if such cases are happening. So in the probation period, Ranlia Garments case, there was a case, Ranlia Garment versus De Silva. 2 employees in the probationary period, they have participated political activities, trade union activities. And then the probation period finished and they were terminated by Ranlia Garments. And the 2 employees went to labor tribunal and they said to reinstate them. But the LT didn't do that. Why? Probation period is there not to actively participate in trade union activities or political activities. You have to study. You have to learn. You have to catch this. Probationary period, you have to pass. Now I have a question for you. A person joined from another company. A person was in X company. While he was in the X company, he has undergone the probation period 1 year and he worked in that company for 3 years. So he resigned from that company and he joined Y company. Y company appointment letter also say you are subject to 6-month probation period. Employees say, no, I completed my probation period while I was working in the X company. It is very unfair, injustice. If you put another probation period, you take me as a permanent employee. What is your answer? Achini, what is your answer?
Sir, as I think there should be a probation period in the second company too, because the policies, procedures, and all other things may be differ than the first company. So we have to check whether this employee is suited with our company too. So we have to have a probation period. but actually it can be shorter than the probation period we have offered to a very new employee who has not worked in any other company and new to this service. So we can offer him a more shorter period of probation, sir.
Can I ask one question? X company also he worked as a chemist. X company he worked as a chemist, and then what happened? He completed 6-month period. Now he resigned and joined a similar company as a chemist. He also joined as a chemist. So do you think he should undergo another 6-month probation period, or just give him a training period and get that? What is your opinion? One thing I agree with you, rules and regulations are different. X company rules and regulations are different and Y company rules are different. Therefore, you can give an induction program. No, if Y company say, if you should go for a probation period, even courts cannot change that. Courts cannot change that. So it is very, very important. What I want to say, every company having its own autonomy. So if they say you have to complete years without any problem, you can. Right, I have another question. Now see Sri Lanka police. Senior superintendent of police. Promoted to DIG temporary post. And in the DIG post, they asked to go through a probationary period. So you are appointed as a probationary DIG. And after 6 months, you will be given the permanence. But when he joined as a ASP, he has completed the probationary period. Do you think he should once again go through a probationary period? Yes or no?
No.
Yeah.
So I think as per the new rank structure, the responsibilities are changing. So
But he has
you can-
undergone probation period before. Yes, your answer is correct. Because they cannot terminate. They cannot terminate the DIG because of probationary. But what can happen? Each post responsibilities are different. So if you are actually undergone probation period while you were in the ASP rank, but once again you should go to that probation period. Otherwise, what will happen? You may not basically study and know the new atmosphere and the culture. These are some questions we have seen. That is very, very important. Another question. Probationary period. If the employee has done a fraud, what will happen? What action the employer can take? He has done a big fraud in the probation period. Can the employer terminate him? Can the employer terminate him? Or whether he is entitled to be in the same place?
Can terminate, sir.
Yes. Frauds and other type of cheating you can. But sometimes you must have a disciplinary inquiry. Otherwise, he also can go and challenge.
Sir, but excuse me, but the public sector doesn't terminate, and the probation period is just extended by the time period. That's it.
Yeah. So it is better the company can have if the company can conduct a inquiry, disciplinary inquiry, or must go and complain in the Sri Lanka police department, right? So these are some of the issues where we have seen. So I have explained many things. So what we have to do, we must look very carefully how you handle the employees. The management has a greater responsibility because employees are not machines. But everything will change with the new labor law amendments. So read the papers. 13 labor laws combine and present as one set. So they will abolish 13 labor laws, and thereafter what they plan to do, everything come under one roof. Everything come under one roof. When it happens, then there can be many more issues are coming. So remember your employees, their standards, how they work, and the guidance you give, as well as assessments. Properly you have to do it. So probationary, once again you are permanent cadre. But the issue in the probationary period, you are still in the cadre, but permanency, for them they have to give a letter. Who is a permanent employee? Permanent employee? Asita Sumana Sekar, who is a permanent employee. Hello?
Permanent employees, the employee who has successfully completed the probation period.
Yeah. Also, yeah, completed the probationary period and
get
placed
the-
in the permanent card. And what will happen basically, all the rights are there. Termination is not possible. You have to follow the procedure very carefully. You have to follow the procedure. And also you have to remember, when you are basically in the permanent cadre, all the rights are vested, EPF, ETF, gratuity, as well as other rights. That means when you are a permanent cadre, if you are in the permanent cadre, to terminate must be under disciplinary grounds or termination of special provision act. Unfortunately, all these laws now, they are going to combine. They combine and present one. A lot of other issues are coming up when it happens. So the draft now circulating, but it has not gone to still the parliament. One day it will go to the parliament, but for the new batch, they will study all the labor laws under one roof, because number one, there you need consistency, and the investors when they come, they need flexible labor laws, hire and fire. But even hire and fire, what will happen? It must be very carefully done. Otherwise, negatively it can be affected for the company. Then you have casual employees. Who are casual? Permanent employees, they can participate trade union actions. They can participate in trade union actions. They have all the right. Before a trade union action, you have to inform 2 weeks before. And then if no solution given, you can participate. Thereafter, you have casual employees. Who are casual employees? Hello? Who are casual employees, please? Who are casual employees?
Hiring employees who need for the company requirements for the short period.
Yes. But
The
still
company
you
can-
have to pay what? EPF? EPF? ETF? If he had continuously worked for 5 years, relativity like that. Casual means sometimes the employee had gone maternity leave for some period. In that period, you can appoint someone casual. When the casual basis is coming, no permanency, right? No permanency. Once the casual period finished, must go for other things, right? And thereafter, casual, continuously, you are not entitled. Sometimes per week, they will ask to come 2 days. Another time, they may ask you to come 3 days. Regular work is not there. That's why you say casual. If an employee gone abroad, then what will happen? Once again, you are placed on the casual card. Contract basis. What do you mean by contract basis employees? Contract basis kya hai? Contract basis. Contract basis. Contract basis means contract employees. 1 year contract, 2 year contract, likewise. Seasonal employees. Have you ever seen seasonal employees? Seasonal employees, who are they, please? Seasonal employees. Seasonal employees means how the seasonal employees
In textile environment, when the New Year season, like the seasons are coming, they are hiring outsiders.
Okay. And also tourism. Tourism, there is a season. For the season, a lot of tourists come to Sri Lanka. Then they are seasonal. You are actually given the work only for that season. Once you finish, then what will happen? You have to work once again. Only for the season. Then you have self-employees. Who are self-employees? You can see street vendors are there. Self-employees. Payment. We have seen many people doing their business, employees. They are all called self-employed. Other than this, what categories are there in your companies? Addition to this. මේවට අමතරව ඔයගොල්ලන්ගේ කම්පැනි වල ඉන්න තව අය ඉන්නවාද? Have you ever seen? මේවට අමතරව ඔයගොල්ලන්ගේ ඉන්නවාද තව දුරටත් මේ employees? Any other employee other than these categories? Yes, please. Only these categories, or can you see different categories also in your companies? Are there any other categories other than these in your organization? If there are, yes, you can say yes, otherwise you say no. Again,
So when it's come to the outsourced employees like
yeah, that's why
security,
I'm asking. Today, other than these categories, outsourced employees are outsourced. Cleaning, legal, likewise. Now, most of the companies, security, legal, cleaning, you outsource employees. So they are not permanent cadre in your company. Abans, they outsource people to big companies. Therefore, they don't have a contract of employment with you. You give the instructions, they do the work. And also remember, the same outsourced employee you cannot expect every day. They rotate. Because the outsourcing company knows if you give them 5 years or 6 years continuously, they will take to their permanent card if the employee is working very hard. So that's why outsourcing, the employer cannot expect same day, every time he will come. The outsourcing company can change them. They know that trend. So outsourced employees are not employees of that company. And the salary, everything paid by the employer to the outsourcing company, they deposit their salary on the other hand. Security cleaning, everywhere outsourcing. Yes. So another type, outsourcing. Outsourcing means there are companies that outsource employees to the other company. So there is another category. Then you have another category. What is that? Labor hire. Sri Lanka, labor hire is not famous. Malaysia, they hire employees from us for 2 years only. South Korea, labor hire. They hire from Sri Lanka. India, like that. So another 2 categories are there. So who are the types of the employees in your organization? Interns, apprentices, trainees, temporary, probationary, permanent, casual, contract, seasonal, and self-employees. So those are very, very important indeed. And what type of work they do. Right. Any question you can ask. Any problem based on that you can ask. Then we go to the other area. Before that, whatever the question you face, please ask.
Sir, employees mean what, sir? Leased employees.
Leasing companies are there. You lease vehicles. Humans you cannot lease. Humans only you can hire or outsource or go with the contract period. Vahanayana lease karana puluwan. You can lease. I think another word for hire, labor hire. I don't know.
Right, sir. Right.
Leasing can be done for property only. Vehicles you can lease. Buildings you can lease for different things. But other than that, when you go for leasing, I heard first time. So your company lease employees. Lease karna dola hai.
Sir, I
All
found
right.
from the document that I searched from the internet, and it says that lease employees is an individual who hired by a staffing agency and then
අරකට
leased
තමයි
out.
කියන්නේ. Labor hire තමයි lease. Hari.
Right,
Okay.
right.
There's no difference.
Okay, sir.
Labor hire, another word they have used employee leasing. So employee hire contracts, which is not familiar in Sri Lanka. Hire කරන එක ඒක හරි. Not lease. අර hire purchase and leasing වගේ තමයි. අපි lease කියන වචනේ ඒක පාවිච්චි කරන්නේ කල්බදු. Then they become slavery. Slaves are no more in the world. All these things are finished. Right. Any other thing, please ask. Any
Sir, is there any other the fixed time period for probationary period?
good question. Sri Lanka, there is no law. Even Shop and Office Employees Act, they have not described an employee's probation period. It is up to the employer to decide. Employer can decide 3 months if he want, 6 months, 12 months, 18 months like. It may not extend more than 18 months because employees may not come to that place. So generally 6 to 12 months, 6 months to 12 months generally, maximum 18 months. So the probation period, there is no fixed one law in the Shop and Office Employees Act, what we are going to discuss next. So even in the Shop and Office Employees Act, it never describes the time period of an employee. They have not given any time period. It is slowly for the employer to decide. It's only for the employer to decide the probation period. It can be in between 6 months to 12 months. Why they give the probation period? To be adjust to the workplace, fit and proper person, and check whether you can handle the situation correctly, language, all these things. So they are monitoring you. Any probation employee must avoid political activities, trade union activities they can do. I can't say like that. But when you participate, they will say most of the time allocation for other things, not for the company, and they can extend the time. So your question is very important. You ask the fixed time period. No, there is no fixed time period for the basic employee. There is no fixed time period. Its final judge is the company. They can decide it, right? Even if the employee contract of employment, if they put 9 years, can't help. You can't fight because there is no law. If Shop and Office Employees Act or Wages Board say the period is basically 2 years, yes, then every company must follow that and see. But you cannot put that. The nature is different from company to company. Different nature of business they are doing. So in such a case, what will happen? You must, ignore that. Probation period, yes. There is no fixed period. Sometimes they don't put the probation period. Sometimes they don't put the probation period. If you are a fully skilled person, they will directly take you to the job. It's all depends with the nature of the company, nature of the business, and the financial situation. Thank you very much for that question. Any other question?
Sir, what about the probation period leave policies? So it is decided
Good
by
question. Probation එකේ දෙන්නේ නෑ leave first year. Even in the Shop and Office Employees Act, you are not entitled for annual leave. Probation are not entitled. But casual leave එකක් දෙන්න පුළුවන්. Medical leave anyway you can give. So casual leave for a year, you have 7 days, so that you can utilize. Otherwise, if you take long leave or additional leave or leave unauthorized, then you can be charged and you have to pay a penalty. Yes, leave normally like permanent employees, but in the first year you are not entitled for annual leave. 14 days annual leave they don't give, but casual leave they may grant. And it's also depend with the employer. If the employer wishes, he may give on right. Any other question? Okay. The first day we discussed the main ILO conventions which apply to the workplace. And also there are specific acts passed for the employee welfare, benefit and other things. So you have to study those things and you have to get to know that. So employees are not machines, they are humans. You have to treat them and protect their fundamental freedom and rights. But in Sri Lanka apparel industry, they are working like slaves. Sometimes their benefits are not be paid. So then there is an institution in Sri Lanka, Labour Commissioner. Narayanpita, 7th floor, you can go and complain to the Labour. Then Labour Commissioner call the company directors and then they will give advice what to do. So it is also very important. Now, considering all these things, one of the major law in Sri Lanka to manage employees in the private sector, 1954 Shop and Office Employees Act. 1954 Shop and Employees Act. Now everyone download 1954 Shop and Employees Act. Please download everyone Shop and Employees Act and go through the main areas, what it discuss. 5 minutes. Samaravir, what are the contents in the Shop and Office Employees? Have you downloaded 1954 Shop and Office Employees Act?
Sir.
Have you downloaded this act?
Yes, sir. Yes,
what
sir.
are the contents, Samaravir? මොනවද තියෙන්නේ මේක?
About the um,
Huh?
about the what do you call?
Yeah. What are the contents? Abhikon?
So
Darshan.
restriction of hours of employment, then the leave, holidays and the other leave type of requirements, then the employment intervals and the other provisions relating to the employment of women personals under 18 and the
Most
provision
of them are correct.
Yeah.
Most
Provisions
of them are
sanitary
correct.
conventions, washing facilities,
Yeah, yeah.
special provisions related to the provisions for breaches of sections and those type of things, sir.
So most of the
Remuneration for period of leave
yeah,
in consequence of pregnancy and other remuneration.
most of the features you explained are correct. Now look, Shop and Office Employees Act. This is one of the foremost law in the country. This is only for the private sector employees. Remember, this is private sector employees. The Shop and Office Employees Act provides for the regulation of hours of employment in shop and office. Private sector employees, how many hours you are working? If you work more than that, you are entitled for OT. Now, if the new law introduced Sometimes you have to work more than 10 hours. This is the problem, no OT. So this law is very clear one. This law is very clear. But most of the rights given by this law will be taken by the new Labor Amendment Acts. So be vigilant. මේ පනත තියෙන බොහොම ඒවා private sector employees ලට සුබදායි. නමුත් අලුත් law එකක් හදන්න යනවා. How they prepare that law? Adding all the labor laws into one. මේ ඔක්කොම එකට එකතු කරලා එකක් හදන්න යනවා. එහෙම හැදුවොත් පොඩි ප්‍රශ්නයක් මතුවෙනවා. What is the problem? Most of the rights can be curtailed. It's a සැරගෙන බලන්න මොකද්ද වෙන්නේ. Anything relation to new labor reforms, please read those articles. දැන්ට Facebook එකේ ටික ටික share වෙනවා. New labor reforms in Sri Lanka, the employees are tightened. Easy for them to terminate from their service. Likewise, many issues may come up. So the Shop and Office Employees Act provides for the regulation of hours of employment in shop and office. Regulation of remuneration, salaries, how to pay. Fixing of wages period, and also provides for authorized deduction from wages. If we have taken a loan and other things, they can deduct. And for matters connected with it, more and more matters are there. So basically, your working hours, your remuneration or salary periods, and authorized deduction from your salary. The Act also deals with health and comfort. සෞඛ්‍ය සහ පහසුකමුත් මේකේ කතා වෙනවා. Sri Lanka, we don't have an Occupational Health and Safety Act. Still, we don't have Occupational Health and Safety Act. Occupational health is very important. Occupational diseases can come up. Tobacco industry, asbestos industry, tile industry. We don't have occupational health and safety. But those who are working in an office only, this is coming now. Any person working in a shop or office. මේ පනත අදාළ වන්නේ anyone working in a shop or office. If you are working in the factory, this act is not applicable. Factories වලට මේක යන්නේ නැහැ. Shop එකක්, office එකක්. Then, if you are working in an office, your health and comfort is covered by this law. Maternity benefits. Maternity benefits කියන්නේ මොනවද? Maternity benefits are the benefits whereby basically childbirth, before the childbirth and after the childbirth, certain maternity benefits are there. Weekly annual holidays, casual, annual holidays are covered by this law. Medical leave does not discuss here. Medical leave, the employer can develop a policy. The employer can develop a policy for what? Holidays. That is called medical leave. Medical leave, Sri Lanka, there is no law. 2 weeks, 1 month, like that. Statutory holidays. What are statutory holidays? The government has declared. Oya holidays are there, mercantile holidays are there, statutory holidays. 8 statutory holidays are there. December 25th, 26th. May, Vesak, Oya, before and after. Then February 4th. Likewise, 8 holidays have been declared. You are entitled. So this law specifically discuss working hours of the employees in a shop and office only, not any other place. Shop එක and office එක විතරයි මේකේ. The salary is paid for them. The wages period. What are the authorized deduction from your wages? And matters connected there. Then the Act also deals with health and comfort in your company. Then maternity benefits, weekly, annual holidays, statutory holidays, as well as leave. Earlier, employees were working for 10 hours in 18th century. But in USA, Chicago, Haymarket incident, after that, the USA government decided to reduce that to 8 hours. And also they work 8 hours today. So we are trying to go back to the situation before 18th century. Employees work 10 hours. Now we are going to work 10 hours. So the employees should understand how you are bear with this. Hours of employment. The normal period during which any person may be employed in a shop and office should be not exceed 8 hours. On any one day and should not exceed 45 hours per 1 week. 1 week. සතියට පැය 45යි දවසට පැය 8. But if you want to get Saturday and Sunday holidays, 9 hours per day, 9 into 5:45, then Saturday, Sunday holidays. That also can be done. So every day you work 9 hours, 9 into 5:45, Saturday, Sunday holidays. But you have to be in the office for 10 hours. 15 minutes tea break, lunchtime half an hour, another 15 minutes tea break. So then 10 hours you are there, but you will get intervals for tea interval, lunch interval. That is one option. Otherwise, you work 8 hours and then 45 hours per week. Half day you have to work Saturday. Saturday, half day. That is also. If you are working more than 8 hours, if you work 5 days and a half, additional 1 hour you will entitle for OT, overtime. Overtime. But executives are not entitled because they get a package. There is a recommendation given by the Labour Commissioner. Executives are given a package, therefore no OT. OT given for other employees. So in effect, a person may employ it for 8 hours during the 5 weeks, 5 weekdays and 5 hours on a Saturday or Sunday. So it can vary. If you work Monday to Friday 8 hours, then you have to work half day Saturday 5 hours. Now Saturday and Sunday, some countries, if you are developing software, those countries are Sunday working, Saturday working, Monday off day. Then they will adjust like that. Overtime. Any work performed beyond the normal hours of work should be remunerated at the rate of 1.5 times the normal hourly rate and appropriate amount for less than 1 hour. Now, if you are working 8 hours, 1 hour salary, how much? If you go OT, 1.5 per hour. Pack වැඩ OT, pack මාර්ක දීමනාව. නැත්නම් ලැබීමක් තියෙනවා. In other words, any person employed beyond 8 hours on any full working day in a week should be paid overtime for working in excess 8 hours on that day. Similarly, if any person working in excess for 45 hours in any 1 week, overtime should be paid, notwithstanding that she may not have exceeded 8 hours on any weekday in that. එතකොට 9 ගානේ වැඩ කරනවා නම් දවස් 5 45 hours no OT. 9 ගානේ වැඩ කරලා Monday to Friday and half day Saturday, for that you have to pay OT. එතකොට එයා පැය 50ක් වැඩ කරනවා. However, an employee cannot be employed on overtime for more than 12 hours 1 week. World Health Organization, ILO, International Labour Organization, they have the standards. You cannot work more than 12 hours. Week එකකටම 12 hours තමයි වැඩ කරන්න පුළුවන්. ඊට වඩා බෑ. Not good for the health. Maximum they will give 12 hours per week. Weekly holidays. Employees who work for not less than 28 hours, including overtime, over meals in any 1 week, allowed 1.5 days. පැය 45ම වැඩ කරන්න ඕනේ නැහැ. Minimum අපිට වැඩ කරන්න පුළුවන් 28 hours salary එකක් ගන්න නම් 28 hours තමයි අපි වැඩි කරන්නේ. So that is very, very important. When you are working, it is much important. 45 hours morning, law එක අනුව 28 hours වැඩ කරාම ඇති. That is a requirement, but companies are not doing it. Most establishments observe the weekly holidays as Saturday and Sunday. Then you have to work 9 hours, 9 to 5:40. The Act, however, does not specify the days on which the weekly holiday should be given. If a weekly holiday is not given in any 1 week, an alternative holiday must be allowed in the following. Alternative එකක් දෙන්න ඕනේ. Statutory holidays. The Act entitles the minister to declare each year total of 9. Then 9 නෙමෙයි 8 statutory holidays. If you get the calendar, you will see 8 statutory holidays. Statutory holidays must be allowed on full pay. Employment on statutory holidays is not permitted unless the prior permission of the Commission of Labour. Statutory holiday වල වැඩ ගන්න බෑ. If statutory holidays employer want to get the employee for urgent work, you must get the Labour Commissioner's permission. If an employee is required to work on a statutory holiday, an alternative holiday must be allowed before the calendar year of any employee and should be remunerated at twice the daily rate. Now, OT normally 1.5 hours rate, but if you are working on a statutory holiday, you will get a twice. පැයට වගේ පැය දෙකක ගාන ගෙවන්න. If you are working in a shop and office, if your hourly rate is 500 rupees, so then double you get if you work in a statutory holiday. In the case of monthly paid employee, the extra payment is 1 additional pay day. In the case of monthly paid employees are there, the extra payment is 1 additional holiday that you have to pay. So statutory holidays coinciding with the weekly holiday, where statutory holidays falls on what it is customary or weekly holiday or half holiday, an alternative holiday or half holiday must be allowed. When you are working statutory holidays coming with a weekly holiday, then additional day or half day must be given. Annual leave. In the first calendar year of employment, an employee is not entitled to utilize the annual leave. මේ calendar year employment employee is not entitled. First year there is a question. Someone asked a question, probation period. So in the first year you are not entitled for what? Annual leave. You are not entitled for annual leave. And then what will happen? If the employee is in continuous employment until the end of the first calendar year, he earns a certain quota of leave. Certain quota ka combined, which can be taken in the succeeding calendar year. The quota of leave depends on the length of service in the first calendar year. On the basis, the following appropriate leave is given to employees in the second calendar year. So 14 days given if the employment commences on after 1st January and before 1st April, you have to work 1 day. 10 days if employment commences on after 1st April and before 1st July. 7 days if employment commences on after 1st July and before 1st October. 4 days if employment commences on no after 1st October. Poya holidays. Every employee is a shop or office should be granted a holiday on a full moon Poya day. But many of the apparel industry garments, I have not seen that day is given. An employee may be employed on full moon Poya day, subject to, however, that the period of employment does not exceed the normal working hours and is remunerated at not less than 1.5 times of the normal daily rate of remuneration. කාමාරට වඩා වැඩි වෙන්න බෑ. OT එකට වඩා වැඩි වෙන්න බෑ. Poya day, yes, 1 hour work, 1.5 payment has to be paid. If the employee is on monthly salary, strictly the extra payment is only additional half-day remuneration. But most employers pay the same rate as the statutory holidays. Where the full moon Poya day on a statutory or weekly holiday, no additional need to be given for the employees for the Poya holidays. Restriction of employment of person under 18 years of age. So the Shop and Office Employees Act totally prohibits the employment of any person who is under 14 years of age. But if you are an adult, you can work. 14 and 18 also a big problem. So the law is very unfair. According to ILO convention, if anyone want to employ, he should be more than 18 years of age. But here it is very, very unfortunate. 14 years mean you are going school. Therefore, compulsory education act is there under that. No person can be worked below 16 years, compulsory education. So 16, 18 also another problem is there. 16 and 18, yes. School time you cannot work, other time you. So persons under 18 years of age shall not be employed in or about the business of a shop or office before 6 a.m. So anyone less than under 18 years, you can't send them before 6 a.m. on any day, provided that any male who has attained the age of 16 years can be employed in or about business of a hotel, restaurant or placement of entertainment between 6 p.m. and 10 p.m. So these are the restrictions given in the law. Restriction on employment of female. If any female, what time you work? Female in a shop or office cannot be employed 6 a.m. or after 8 p.m. provided that a female who is over 18 years of age can be employed in the business of a hotel or restaurant between 8 p.m. and 10 p.m. After that, you can't. But a female of 18 years of age can also be employed before 6 a.m. and after 8 p.m. in an office of airline, at an airport, as a ground hostess, or in a residential hotel as a receptionist, ladies cloakroom attendant, linen room attendant, or lavatory attendant. That you can. So the Minister of Labour must gazette which employees female can work night time. Now there are data centers. The Act never say a data center, but the minister can gazette it. Minister can gazette it. These places are also coming under what? Employees, female, they can work night time. They can work basically night time, but you have to come up with a gazette. If the gazette is issued only, you are entitled for them. So these are some of the restrictions in an employment. So you have to read very carefully. You have to read all these things very carefully. Once you read these things, you will understand how this works. All right. So today we covered the Shop and Office Employees Act. This is only a brief slideshow. But you have to read and understand. Many things are there. So homework, read the Shop and Office Employees Act and see whether it is suitable for today or whether you are proposing many new things. So those type of question we ask. What is the question? Whether the Shop and Office Employees Act is... Now this is 1954. Reforms are needed. So we cannot... What reforms? You are proposing to amend the Shop and Office Employees Act. You are adults. You are doing masters. Masters, we are giving the guide and the directions. Thereafter, what will happen? You all have to give the proposal. That is very important. Okay. So we will meet next time and discuss another legislation. So time to time we are discussing many more things. Many more things. So up to now we have done the introduction, identification of the employees, contract of employment, labor, employee involvement and employee participation, and how to identify the employee, contract of employee. So I will give the notes to the coordinator to upload in the LMS. In the meantime, notes are not enough. You have the web, you have all the necessary materials. Please download that, read it, and understand this lesson. Even I delay to come, you have to read and understand. Undergraduate and postgraduates are different. You all have to do all these things. We are doing the guidelines. Okay, thank you very much. We'll meet next time.
Thank you, sir.
Thank you, sir.